Good evening to you. Thank you so much for staying with us here on Nationwide at 5. I'm Ricardo Brooks.
My name is Sanjay Lewis, and it's now time for the nation's business. Constitutional Affairs Minister Marlene Malahou Fort is chiding opposition leader Mark Golding for his posture towards the constitutional reform process. For the third sitting in a row, Golding made good on a promise to absent himself and opposition members from the Joint Select Committee reviewing legislation to transform Jamaica into a republic. Minister Malahou Fort says Golding has convinced himself that only he and the PNP are legitimate contributors to the reform process.
Mr. Golding said Prime Minister Andrew Holness' failure to state his position on the Caribbean Court of Justice being adopted as Jamaica's final appellate court will impact the willingness of the opposition to take part in the constitutional reform agenda going forward.
These are matters relating to consensus in the reform of our Constitution and require answers to be provided by the head of government himself. Those answers are long overdue. Madam Chair, the answers that are forthcoming will determine the character of the opposition's cooperation in this exercise. The opposition is pushing for both sides to work together on both initiatives. We, as the opposition, need to be convinced that there is any better way forward than that.
That's opposition leader Mark Golding. Now, the committee held its third meeting on Wednesday, and as in previous sittings, Golding and his opposition members were absent. Malahou Fort described the opposition's boycott as selfish.
I think it's important to put on record that the other members of the committee who gave of their time, they are not to be viewed as making an illegitimate contribution. Jamaicans who were invited to serve, they were not legitimate because they were not selected by the People's National Party or its leaders, nor were they selected through a process that was dictated or led by the opposition.
And that's Marlene Malahou Fort, Constitutional Affairs Minister. She says the opposition leader's move is a disservice to the country and the Jamaicans who gave of themselves to take part in the constitutional reform agenda. According to Minister Malahou Fort, Mr. Golding's stance is not surprising, but disappointing.
I'm not really surprised by what has unfolded, even though I was hoping to see something better, especially when we're so near to an election and we want to demonstrate to the people that we have what it takes to be entrusted with the reins of leadership. So when I read through the statement of the leader of the opposition, a lot of what is said seemed to be not in keeping with what is verifiable. In fact, like I said, the terms were set out and the terms were agreed. So no one was taken by surprise about a phased approach. And no one should have been taken by surprise that the issue of the court was set for the next phase, because we were focusing on the deeply entrenched provisions.
That's the Legal and Constitutional Affairs Minister Marlene Malahou Fort. She also chairs the committee considering the Republic Bill. Joining us now, a member of the Constitutional Reform Committee, Dr. Nadine Spence, and public commentator Helene Davis-White. Ladies, good evening.
Good evening.
Good evening, Ricardo. Good evening, Sanjay. Good evening, Helene. Good evening, everyone.
Thank you so much for joining us. Dr. Spence, let me start with you. It seems like all the work you did will be for naught. This doesn't seem it's going to go anywhere.
Because remember, before Parliament, that Joint Select Committee has been put together.
Sorry, Dr. Spence, you have us on speaker?
No, I haven't let me hear.
We're going to ask you to shift that.
All right, so I'm saying that
much better.
A bill is before Parliament.
Mm-hmm.
This has not happened before on the matter of the Republic. This has not happened before. So even so, I think if it doesn't move beyond this bill stage, at least we would have progressed further than any other constitutional reform effort in Jamaica. Something,
mm-hmm.
Ricardo, I don't know if you or it was Sanjay who was interviewing Sumit Bisaria from International IDEA, who are the watchdogs on constitution-making processes globally. And one of the things he said in meetings with us when he came here was that 90% of constitutional reform efforts globally fail.
Mm-hmm.
So it's a tenuous process. It's problematic. Wherever in the world it is being practiced. I don't think we should give up on it just yet. I think that there are so many constitutional reform efforts where talks break down and different things happen that would. I think the processes that are going to succeed are the ones that persist, that find a way past the difficulties and the roadblocks.
Helen Davis-White, let me hear you. How do you assess the opposition's decision to boycott the Reform Committee meetings? And is it that the position put forward by Mark Golding a legitimate one?
Well, I'm not sure if it is legitimate, but I understand the opposition's approach. I remember when the reform process started, and some of us felt that, it was loaded, the committee was loaded with too much legal mail. And some persons took the view that, for constitutional reform, it is a legal process, while others said it's really a political process. And this is what is actually being played out now, because it is about what you would want in terms of how your country should be organized and so on. So yes, legalities are important, but it is a political process. And in this situation, the opposition has taken the position that they would prefer if the process went a particular way, particularly regarding the position on the court, the final appellate court. And, in a political process, you are going to use whatever you have at your advantage to be able to get what it is you want. So I expect that this is what the opposition would be involved in. I would say, though, that for a lot of Jamaicans, when this whole thing about constitutional reform came about, a lot of Jamaicans weren't actually taken with the phased approach. They wanted, real, quote-unquote, real reform, and this thing about going in this phased way. I mean, if you attended some of these sessions, persons felt that, this is our time to be involved, and we're talking about, the whole hog, and the government is actually taking us down this phased route. And so, truth be told, I think the opposition is using whatever it has now, it feels as an advantage to be able to try and get what it is that they would prefer in terms of the process. Their view is that you can't talk about doing away with the monarch and retaining at the same time the association with the monarch's privy council. And so they have linked it. And some persons would agree with them for having linked it, because it sort of, begs the question, if you feel that you don't want the monarch, why should you want the monarch privy council? So
But
I think that is what they are using, and they're using, whatever political muscle they have now to try and get that issue settled at the same time as they are settling the question of the removal of the monarch.
But Dr. Spence, following up on what Helen Davis-White just indicated, can it really be all or nothing? You don't agree with a particular position that the government putting forward. Do you take up your marbles from the table and shut it down? Is that a good negotiating strategy from the opposition?
But hear what? I just want to address some of the things that Helen said, right? Mm-hmm. The first thing she said was about the phased approach. One of the feedbacks that we now have from International IDEA, who gave us comparative information on constitutional reforms efforts globally, is that the phased approach is a best practice in constitutional reform practice, because one of the reasons why constitutional reform efforts fail is because people take on too many things at the same time. And what this phased effort did was it put together reform efforts that demanded, that was purely a matter of logistics. Matters that required the same reform process were put together, and a phased process was laid out, which clearly stated that the matter of the final court, which is not a deeply entrenched matter, will be handled in this second phase. And so when we had that conversation with International IDEA, which is I'm thinking too fast, I don't remember what IDEA means right now. One of the things they said is, when we look at constitutional reform efforts globally, we find that because constitution makers tend to put so many things on the agenda, including those things that are contentious and for which there might not be the kind of support that is expected to carry a reform effort through, particularly a reform effort that requires a referendum, it is best it seems best to not put all of those things together.
Mm-hmm.
That is one thing. The other matter about too many legal minds at the table, this is not what is at hand now. It's not because, and I'm not a lawyer, this is not what has caused the problem. No, what has caused the problem is that the opposition has said, either you put the court in the reform effort, or we will not support. Remember, our Constitution asks for a process that builds consensus now of the process taken by the CRC and the process taken by the government and by the opposition. Which one seems to be a more consensus-building effort? Because there are some people in Jamaica, and I might not agree with them, and Helen might not agree with them, and you might not agree with them, Sanjay, but there are some people in Jamaica who believe that the CCJ should not be Jamaica's final court. Mm. And so what are we saying about those people? That if you do not believe that the CCJ should be Jamaica's final court, then your opinion shouldn't matter. So should we take the process that says, let us build towards consensus, or do we take the process that says, this way or the highway?
And that's what I wanted to pick up with you on, Helen Davis said, because I'm a little bit troubled, because Mr. Golding says we must accept the CCJ. Dr. Spence is quite correct that there are people who are passionately opposed to that court for whatever reason. And then Mr. Golding also says he's also against a referendum to decide the question. So it almost seems to me as if he's saying, do it my way or we will not do it at all. Because even if the government were to come to say, okay, fine, we will put the question of the court to the people for them to decide if that is the court they want. Mr. Golding is also saying he would not support that process. So I guess my question is, how do we settle that kind of tension then? Because he only seems to be accepting one way, which is that put it in now and pass it through the parliament, or we won't cooperate at all. How do we resolve that?
Being a trade unionist and somebody who's always involved in negotiations, there are times when you have to adopt positions based on the particular circumstances and the environment in which you are operating. So, as I said before, Mr. Golding obviously is of the view that this is the opportune time for them to be able to try and settle this question. And that is because, if you, as I said before, if you are talking about the monarch, removing the monarch, why should you want to retain the monarch's Privy Council?
Yes. And
so that now presents the choice that you have, because you can't, to my mind, at one stage say you agree that you should remove the monarch, but some of the vestiges that are connected to that monarch you want to retain. And so that is their position, and they believe that this is the time that, you should push for some kind of decision on that. You may disagree, or I may disagree with their approach, but that is clearly how they have looked at it. In terms of consensus, I am one that is all for consensus building. But a lot of the times when you seek consensus, but there are times when you have to decide if you are not getting the consensus, how do we move ahead? Do we stay in this particular position until we get the consensus, or do we take a decision to move ahead? Because consensus means everybody has to agree. There's very little circumstances where everybody agrees. And that is why democracy is really about what the majority wants. If you're looking for consensus on everything, you may never get it.
And then, so then isn't the best way then to settle what the majority wants, perhaps to put it to the people for a direct vote? Mr. Golding says he's opposed to that as well.
But remember, that the consensus that we are talking about is the constitutionally laid out consensus, which is what needs to happen for the reform to happen. So in other words, it's not just me and you agreeing. And, I don't remember if it was Bruce Golding or P.J. Patterson who raised this conversation, this issue at the lecture that they had at the university, at the Faculty of Law. One of the things they said is, if you are an opposition leader or a leader of government in this particular scenario, do you, given what the Constitution has laid out on this matter of constitutional reform, if this is the agenda that we are pursuing, do you have the luxury of withdrawing, since the Constitution says there is a process that you need to follow to get to constitutional reform, and this is clearly what the people want. That's one. Mm-hmm. I think Mr. Patterson has suggested that you lock them in a room until they come to some agreement, because in his mind, you don't have a choice. You can't walk away from it.
I think that's how
you can't afford.
That's how they used to do it in the ancient Roman Catholic Church when they were electing the Pope. They locked them in a room, and then the longer they took, the more they exposed them to the elements. So they took off the roof, they took off the windows.
So consensus building is what our Constitution requires. The other thing is, even though in some parts of the Caribbean people went to being republics, so like Trinidad, for example, became a republic in the 1970s and still retains the CCJ. No, sorry,
the Privy Council.
The Privy Council.
Yes.
And you see, even though there is a methodology that is laid down in terms of practice of constitutional reform in the Caribbean, which says we do them one at a time. The people's appetite for change must be managed, must be understood, and you cannot push too much change in people's face at the one time. And you must also understand the public enough to know what people are calling for. On this matter of the CCJ, people have not come to a comfortable position as to what they believe should be Jamaica's final appellate court. And that should be understood, but also that change does not require a referendum. Mm-hmm. It is a political decision which both parties must sit down and work out, because we know the PNP has tried it already. And I think this is where a lot of the bad blood is coming from, right? The PNP tried it already, and it was the JLP contested and so on. So the JLP's position is clear on it, right? They do not necessarily believe that we should move to the CCJ, and they have said they think a Jamaican final appellate court is a possibility that we should also consider. So clearly we don't have consensus on this matter.
Right. But here the problem now, Nadine, because the government is insisting that the reform process must continue despite the opposition's absence. But can a constitutional transition to a republic be truly legitimate without bipartisan consensus?
It's not even whether it is legitimate. It can't happen without bipartisan consensus. Yeah. And so, no, it can't happen. That's why I said to you that in the conversation with Bruce Golding and P.J. Patterson, I don't remember which one or if it was both of them. I might be misquoting. Forgive me. They asked, do we have the luxury of walking away from such a process if the Constitution has laid out a process which says this is what we must do? So what the leader of the opposition and the Prime Minister needs to do, and the people who are around them, and is proceed to then have the conversation about Jamaica's final court. That is what needs to happen. We don't know how long that process is. What we do know is that the phased approach allows for that process to be worked out between the political leaders before the legal considerations are put to the Parliament.
I think
what the phased approach allows for is an eventual working out of that issue. We can't discard one side's opinion. We have to ask them to sit down and work it out.
I think, what is being played out here is whether or not there is trust that when you go through this first phase, that the issue of the final appellate court, whether or not, the government or the JLP will feel the need to go down and actually settle on the issue. So, as I said before, the opposition is clearly just using what political muscle they believe they have to be trying to get the government to move on this particular issue, because, as I said, it's really just about politics, a political move right now, and they think that this is the time, because the government wants to go down the road with the constitutional reform. They also, I would believe, would want to go down that road, but now is the time when we should be settling on the CCJ, because if not, you may find that it gets shunted to the back burner, and you never actually get a settlement. So it really comes down to, do the two sides trust each other? And I think that is really what the problem is.
Do we need, Helen, at this point, to maybe call in an elder statesman like a PJ Patterson and maybe a Bruce Golding to sit down with the leader of the opposition and the Prime Minister to see how we can reach a consensus and move this process forward?
Well, that may be an approach that could assist, because as long as they are prepared to sit with each other at this particular point in time and to have the conversation, because clearly without that conversation, we're not going to be able to get the consensus that is desired or required, as Nadine says. The truth of the matter is that if it is that the trust factor is being, that this is an issue. If in fact you don't have somebody who can go in and build that trust, I don't think we are going to get anywhere with the process.
But remember too, Helene, that one of the things that the Prime Minister spoke to at the start of this was on the matter of the Republic. He had received a letter from PJ Patterson on Jamaica's 60th anniversary, and also an invitation by the leader of the opposition in the House, which said there are some matters for which we have agreement. Let's proceed with those matters. And one of the things is, if you remember the Prime Minister's response, his response was, if I did not believe that we had consensus on these issues, then I, as leader of government, I would not have asked that we proceed down this route. Because in my mind, if we don't have a consensus before we start, then we can't proceed. So clearly there was consensus on the start. There was an invitation from the most honorable PJ Patterson to say, hey, get on with it. It's our 60th anniversary. Why are we taking so long? We can move to this. There are some matters for which there is consensus. And the leader of the opposition, the same leader of the opposition who is making this statement now, got up at that point and said, get on with it. There are some matters for which we have consensus. So I think that it is confusing for me that now that we're at this stage, this matter is being held to ransom by the matter of the Caribbean Court of Justice, when it was always obvious that for this matter of the final court, more work needed to be done to get everybody on the same page as to what it is that Jamaica's final appeal court will look like.
Nadine Spence, Helene Davis-White, thank you so much for your time.